Hey everyone, this is Stephen Roddy, co-founder of Modern BeautyCon, and today's guest is Justin Marty of Marty Law Group. And this particular episode is going to be for if you've ever, it's the med spa owner or maybe the a subcontractor injector who's wondered like, how do I, am I in trouble? Like, what do I need to do to stay out of trouble before I get into trouble? And I mean, I feel like I'm public enemy number one at this, so it's really good to be on the interview side because I can just ask all of my questions of like how I accidentally broke the law or wasn't compliant, and Justin can use me as a tool here. But he is here. He owns a firm called Marty Law Group, and it's a firm that's laser focused on the legal needs of the medical aesthetic practices. Justin isn't just your typical attorney. He's also an entrepreneur and operator at heart with real world experience running and scaling businesses in the dental space. And that means he understands the legal side, the day-to-day pressures of a growing med spa, all the things that you're going through and what my wife and I are going through. So at Marty Law Group, Justin's team specializes in compliance strategy, mergers and acquisitions, protecting practices from costly legal mistakes, whether it's with staffing, patient care, or staying on the right side of the state and federal regulations. And today he's here to help you and me understand how to stay profitable and stay protected. And as a side note, Renata and I have hired Justin to work on 3 out of our 4 companies. And he and his team are just great humans. And it's, not normally that you say that about your lawyer, but like we really like them just as humans. And they happen to know their stuff too. So it's a win-win. So Justin, welcome to the call.
Thank you for having me. I love the intro. So I'm glad we're okay humans, even for lawyers. Thank you.
Yeah. There's so many jokes that you can like drop in there. But let's start with staffing. Like, what are some of the most common mistakes med spas make when it comes to employee classifications, pay structures, contracts?
Yeah. So this is and I should preface this too. Like I struggle, right, with this. I don't know if it's the word is the imposter syndrome or what, but really wearing the 2 hats of like at my core, right? Like I'm an entrepreneur, I'm a risk taker, right? That's what we do. And when you're an entrepreneur, you're like, I have this vision and it's crazy, but I'm going to make it happen. And balancing that with lawyer life where it's like cynical and don't do this and don't do that. And like, you're going to get trouble and go to jail. So I kind of struggle with this, balance to find. So obviously today I'll talk a lot about like the don't do this or be careful of that. But at the end of the day, we want people to obviously succeed. And so I think that's where our kind of advisor first, a lawyer second mentality comes from. But that being said, I kind of preface that because I feel like I'm going to give a lot of, this is wrong and that's wrong. But so to answer your question, really there's probably 3 areas that I see when it comes to staffing, the biggest issues that folks run into or exposure that they could have. And you hit it on the head. Like the first really is kind of misclassification of employment status. So as business owners, right, we love having probably independent contractors over a W-2 employee. It's, saves us a lot on taxes and there's some flexibility there that money frees up for us to do other things. You mentioned before, right? I had 45 dental offices with my partners. At one point in time, we didn't start there, we scaled to that. At one point in time, everyone was a contractor. And our CPAs came in and are like, you have some massive exposure here because these guys, these dentists who work for you are not all contractors. And so that was pre-lawyer life. And I learned, that we have some exposure by having everyone miscategorized. So really the IRS kind of like oversees this categorization of what's a contractor, what's an employee. But at the end of the day, like a contractor truly is someone who's kind of running their own business within your business. And it all turns on control, right? So if they're controlling their schedule and what supplies they use and all these things, then they're a contractor, In most cases, it's probably not what's happening, right? They're probably more of a true employee where you're telling them, hey, here's your schedule and here's your staff. And, I'm going to load up your patients.
And could they also use the rule of thumb where it's like that if a contractor has several other businesses that they work with, they're probably maybe a contractor.
Yep.
Okay.
Yeah, that plays into it. And if they're if they're precluded from doing other things, again, you're as the employer will say, you're in control, and it's probably an employee.
What if somebody is renting a room like inside of your med spa, but it's under, because that's one of our first employees like rented a room, and before everybody now is W-2. But we had this big space, and somebody's like, "Can I rent a room?" We're like, yes, you can. So we treated her as a subcontractor, but we're the only place that she worked.
If she's renting from you or was renting from you, that definitely lends itself to more of a contractor arrangement. And again, it'll depend. I'm a lawyer, right? It depends, but it'll depend on so many factors of if she was renting from you and seeing her own patients, or maybe bringing patients that become patients of the practice, but like she's really making the decisions. Steven, I'll be here this day and this day. I won't be here those days. That's much more of a contractor relationship. Generally, like an employee's not renting space from you. So that will play into it.
And then what about pay structures?
Yeah.
So, if I jumped over too soon.
No, you hit on the head. My next word was compensation. Okay. So this is another area that gets, sticky. And again, like as the business owner in me, performance-based compensation works, right? Like we want to incentivize my attorneys. Like I want to incentivize them. We want to incentivize injectors. It's just a slippery slope. And so every state, and I should preface all of this, it's not legal advice. Like we got to look at your state regulations. You guys are in Massachusetts, but we work across the country. So every state's very different. A lot of states will preclude like non-clinical folks from sharing in clinical revenue, right? So like, again, at our dental group where I broke every rule, our front desk people, they were incentivized to fill that schedule, and if they did and our revenue was up that month, like they were getting bonused on it. Now, what we've really learned is in most states, we just have to be really careful of not tying those non-clinical folks to like getting a share of production or of, the revenue that comes in. So that's a classic case of fee splitting. And so really, in a lot of instances, the injector can probably get a piece of their own work, their own kind of revenue. Sometimes they can share in the overall practice, but it's just so state dependent. We have to be really careful about, how we structure those comp plans. So we work with, a lot of the fractional CFOs to put those together because it's like above my pay grade.
So to back in that a little bit, when we were interviewing for a new esthetician, there were so many of us like, "Oh, like, do you do kind of commission-based pay?" And we're like, "No, we don't. That's actually not legal in Massachusetts." And people are like, "Oh, well, my last 3 jobs at these other med spas, like I did it." And like, okay, well, they're breaking the law, but what's the likelihood that they're going to get caught? It's fractional probably, but if you do get caught, it can be like really big. In Massachusetts, we've got people illegally injecting Botox all over the place, and they're not really, it's not even Botox, it's some Chinese knockoff. Right. And they're not necessarily getting caught. So it does make it challenging for the people that do try to follow the rule. Like when you're up against these interviews, but you want to stay in integrity. But that said, our office manager, if we hit, and let me know if this is compliant or not, because I haven't written this by you, but if she hits the projections, like we create projections, if she hits those numbers, like as a spa, then she's bonused X. Yeah. If we go over it as a spa by like 5%, then that increases 10%, 15%, and it increases. Is that compliant, or is that like you're actually not allowed to do that?
Yeah, that's one of those areas, and we can check Massachusetts again, but we know it's pretty strict, right? It's one of those areas that you want to be careful, since she's non-clinical, of tying her bonus to revenue, right? To these revenue goals. And again, like it works, and it's so hard to balance that. So a lot of times we'll try to massage the language a bit, and whether it's like a patient satisfaction goal, like build something else in there that's like, hey, so it's not directly correlated to revenue. Again, that's the motivator. She's going to be motivated to hit numbers, and the more you do.
Yeah, to your point, I have never seen someone do such a 180 to be like, hey, where are we again this month? Like where
Right,
like,
right, right.
it was great, like for the overall practice.
Yeah.
I was like, okay, good. The bonus structure is doing it, but maybe also tie it to could you tie it to membership numbers? Because like, oh, we have to get maybe 5 new members
Yeah.
on our monthly. Would that help make it like more compliant?
Yeah, I think so. I think if you, and it's, we get a little cute, right? Sometimes with it, but I think if you're backing into the number you need to hit as a business owner, candidly, but you're not tying it directly to like, this, now we know that many members might bring in this much revenue. But if you can tie it to something like that, again, more members, maybe that stems from patient satisfaction or whatever we want to tie to it, it'll definitely put you in a better light. And like you said, like, there's usually not like the compensation police kicking in the door to like be like, you're Steven, not
Show me your books.
when they start peeling back layers and when there is an investigation or something, like you just want to make sure it's tight because then it opens you up to more exposure.
Yeah, completely. And like for me, it's about wasted energy. Like if in the back of your mind, if you're like, I probably shouldn't be doing this, it takes away energy from other things like building your business, creating profitability. Because in your back, it's just like, I don't want to get caught doing that. And in my mind, you can't really build a successful life if you're like living in sin, so to speak, and keep the sin, and it'll free you up for a bigger return.
That's
All
right.
right. So we did the employee classification, employee structures, contracts. Like I know I think they just did away maybe federally with like the non-compete clause for employees, or maybe that was just in Massachusetts.
Yeah. So this has been the wildest thing to watch next to like the GLP-1 craze. But so the federal government, out of nowhere, right? The FTC, the Federal Trade, out of nowhere was like, hey, we're going to ban all non-competes. And there was this whole debate of like, do they even have the legislative power? But it started to go forward. And then a court, I forget where, like in Texas, I think, like kind of shot it down. Then it was back on, then it was off, then it was on. So now it never rolled out. Like this federal ban never rolled out on non-compete. So it is still very state dependent. Massachusetts has a ban on non-competes for physicians, which is in our industry, right? Very, very spicy because there's so many NPs and PAs and, it doesn't really apply to them. It's really for physicians. Other California, they're all, it's all kind of banned. Jersey's working on a ban. So really it's very state dependent. And like, without going too, give my dissertation too much, like it really depends on the scope of a non-compete. So like we always say is reasonable, which is this like arbitrary lawyer term that someone came up with, right? Like, and they're like, well, I don't know, is it reasonable? Is it not? And somehow that's like now a legal term. But reasonableness usually will depend on like the geographic scope, how many miles, right? And how many years. And those are the two big things. So, I mean, we see some like egregious employment agreements where it's like, you can't work in New England for 7 years if you leave. And that's probably not enforceable in court.
Right.
If you're in Boston, it might be like half a mile, right? And like a year or something. It really depends on the geography. So all those factors play into it on whether it's enforceable for non-physicians anyway.
Yeah. And I always kind of go back to like when it's contractual. I'm like, all right, am I really going to enforce this? Like, let's say somebody does go down, because again, like for me, there's a certain amount of energy that's required and resources to go after that person to say, no, you can't work at A, B, and C Med Spa.
Right.
And so if for me, like contractually, if I know I'm not going to like go after the person or like really enforce them, like it doesn't. Yeah, I'll put it in there, but it really, I hold it with an open hand. Like, okay, if you do go down the street, and if that really crumbles my business, I probably didn't have much of a business to begin with, right? Like,
and I think like you can, I think you can really distinguish a non-compete from a non-solicitation, right? I think that's it is really different. And a non-solicit, you always want that in your contract too, right? People have the non-compete, but you really, more importantly, want the non-solicit. And that's where someone goes down the street, right? And the last day at your office, they print out the patient list. They go down the street. Now they're calling everyone. Like, it's really different than, right? I go get a job somewhere else and trying to make a living doing what I was trained to do.
Yeah.
If they are soliciting your people and you can show that, that's, very enforceable, right? And
Yeah.
so, sometimes in the contract, there'll be a per patient penalty. Again, you
Mhm.
have to show that these people solicit. I mean, and we see the craziest things. We see like blast emails that went out, and like the employer's like, really, like you literally emailed all my patients. So don't do
Yeah.
that, or make sure that you have, if you're a practice owner, you have in your agreement the non-solicit, because really it's probably more important than the non-compete.
One of the things that we stopped doing as a practice, and I see other practices doing this, is like each one of their providers will have their own social, like, Jill aesthetics queen, at Instagram. And I was like, we're only going to have Roddy Medspas Instagram. Now we'll feature you on that because we had a few turnover, and the 53 followers that they had anyways were our patients from Roddy Medspa that followed them,
Right.
but then they own it. So then they flip it, and
Yep.
then now they take those 53 people away. And even still, like when we had an esthetician leave, she became friends with some of the people, and we're like, you're like, you're following her. You guys are following each other. She's like, well, we're friends.
Right.
Like, well, yeah, but this is the patient's, like, this is a practice patient. And if you're following them and like commenting on their stuff, it's a form of solicitation. Please stop. But so that social media gets really tricky there. But that's one of the ways we stopped it.
Yeah, now it's really big. I mean, because of the industry's exploded with everyone's an influencer, right? All of a sudden. And so we've really beefed up, I think, when we're doing an employment agreement for a practice owner, like we really have a lot on there about the intellectual property and the before and afters and who owns them. And sometimes if the injector has a big following, we're like, cool, post it and we're tagged in it, we being the practice owner. But again, if we part ways, that's like our content, right? Practice. So I think that's super important as well.
Yeah, that's good. All right, let's move on to, we talked some about this, but just to touch, actually, let's skip over the independent contractors, because I feel like we already hit that pretty good. Independent contractors versus employees. So around compliance, what's one of the biggest compliance blind spots when it comes to supervising injectors or delegating treatments? I mean, this could be like we have an RN that works at our med spa, and we're not has to do what is it? Not a compliance. A
good faith.
What is it? Yeah, good faith exam. That one. Yeah. So, what are some of the biggest blind spots there?
I think the medical director oversight is like so underappreciated. And when we see an investigation, right, and once you see enough patients, I learned this again the hard way. Like once you see enough patients, there's gonna be some patient complaint, a disgruntled staff member. Like once you get big enough, something happens, or competitor, and there's the board shows up one day, right? In our case, it was the dental board, but the medical board, nursing board, they send in a request for info, and that's when the lack of oversight really comes to like the forefront. If there is a lack of oversight, there's services out there, right, that I call them kind of like, with all due respect, like kind of a doc in a box, right? And like they kind of lend you a license, and the nurse is like, sweet, let's go, I have a physician's license on file. And it works until it doesn't, right? And when there's an adverse event, the boards are getting really strict with like, hey, what's the medical director oversight? We want to see the documentation of all of it. Are there chart reviews? Like all of that needs to be really tight. So, and it doesn't just have to be the physician, right? It can be Massachusetts, can be a nurse practitioner, depends on the state. But I think making sure like the medical or the clinical director is really involved and actually looking at the charts, and again, state dependent. Sometimes they have to be within a certain radius, sometimes they can be anywhere, but they need to be reviewing a certain amount of charts. Like it's so important that's happening.
Yeah, so when you're saying documentation, like when Renata hops in and does a good face exam for the RN, how does that have to be documented in this instance? Where, like paper trail, does there have to be anything like your not company bylaws, but what is it, the company rules or playbook, employee handbook?
So good faith exams or GFEs, huge exposure point as well. And you want to make sure it's well documented. You have, your EMR, right, might have a place to kind of track all of this, but you want to make sure that there's like a robust one-on-one meeting before you do any treatment with the patient. And again, it's got to either be a physician, a nurse practitioner. Sometimes it could be a PA. It depends on your state, but Renata popping in there before the nurse kind of puts hands on patients is the key. And again, it doesn't necessarily have to be kind of a paper form kept in a file somewhere in this day and age, but really well documented in the EMR system, and go through the medical history, right? Like just like when you go to your primary care, doesn't have to be done every time. We suggest, like, certainly if there's a change in medical history, something happened, like do a new good faith exam, have Renata look at them. If nothing else, at least annually, kind of get a new one on file. And then there was one other situation where, a new treatment, right? So maybe they came in for injectables at first, and so she kind of cleared them for that. Now they want to, get into lasers. So, doing a quick GFE is a good idea. There are a lot of virtual GFE. I shouldn't say a lot. There's a few virtual GFE services, which, the patient's there. And if the person doesn't have a Renata right nearby, they pop up on the phone or the iPad and they do a virtual GFE. And in a lot of states, that's fine. But there are states, Connecticut, for example, just kind of remove the ability to do a virtual GFE. Wisconsin on it. So there are states who people have to be really familiar. Again, like 99% of places are probably not compliant, unfortunately, and they're like not even aware that the regs changed. But it should be done like before these treatments are being performed.
Well, we've got a service. I think is it Patient Now? I don't remember, but we use a virtual one for when we introduced that when Renata was on maternity leave, so we could do that. And then it just kind of it stuck for when Renata's off and our RN is working. But we're also, you have to check with your state and all that. But Boulevard, it's a EMR, it's a booking software that we're switching to through our Medspas. They have a GFE on there that's compliant. Right. I'll have to have you check that out. But basically, you upload photos of it, and then Renata then can see those photos, and you can see, because the RN can say, all right, 4 units, 20 units, whatever, and then Renata can look at that and then sign off on it right there, and then gives her a notification in the next room that she's all ready to go. So that's some other options too. Regarding compliance, there's a way that we were very uncompliant. So, which I'll show this and then you can tell us. But we were talking to another med spa owner at a conference. It wasn't Modern Beauty Con, it was something else. And they're like, oh yeah, like Renata owns the med spa, right? And I was like, oh no, I mean, we own it, like, 50-50. That's like how the paperwork says. And she was like, you're not a medical professional, are you? I'm like, oh no. She was like, well, in Massachusetts, Renata owns 100% of the practice because you're not allowed to own anything. And I was like, oh,
yep.
Okay. Yeah. We need to course correct that ASAP. So we were compliant or non-compliant for probably the first 4 or 5 years of our spa, just out of ignorance. Like, oh, husband and wife, whatever, 50-50, I handle the business, clinical, moving on. So any words of wisdom about that?
No, it's so common, man. Like, we see it all the time, and people don't know, right? They don't have like ill will. They're like, let's start a med spa together. Let's go. And, so Massachusetts, right? Like Connecticut is a corporate practice of medicine state, or CPOM or CPOM. You'll hear me nerd out on CPOM. And that's what it is. It's basically like, in certain states, you have to be a physician, or they've expanded it to nurse practitioners or PAs in some states. But you have to be this kind of clinical professional to own it. And like, we see it all the time. It's probably the most difficult discussion. I'll get an RN on like Zoom, and they'll tell me how they have this $2 million med spa, it's flourishing, and I have to be the bearer of bad news. Be like, technically you can't own this thing. So let's talk about that. And there's structures we can put around that like can make it compliant, but it really does involve us pulling in a physician or an NP or something. And it's really tricky for the spa owner to like be okay with that, because it's their baby. But you hit on the head. Like, there's so many situations where people are in these, these states that unfortunately you can't own it. So we have to kind of build a structure that allows you to work around that.
Well, then we found out that we weren't compliant because like Renata owned Modern Beauty Con also and a Medspas. So then Allergan and Galderma, whatever, they couldn't sponsor us because it's like them paying a med spa.
Yeah.
So it's like, no, Renata doesn't own anything of Modern Beauty. Steven owns Modern Beauty Con. Renata owns Roddy Med Spa. It's like very, very different, you know. So we had to like back into that too. So I was like, oh gosh, never thought about that angle. But
you figured it all out though. I mean, it takes time to figure out fee splitting, CPOM, you broke every rule, right? And now we know. So, you know, we have that in
so many rules.
I didn't really know what I was doing.
Well, that's the thing about being an entrepreneur, right? You just like, all right, you see an opportunity, you see, here's a solution, but blessed are the flexible, for they shall be flexed.
That's
so
right.
like when you're doing something wrong, just, okay, course correct and get back on track.
Yeah.
Okay. So that's, can we talk a little bit about HIPAA? Cause that's kind of like compliance. I heard it said, you know, that med spas don't have to be HIPAA compliant if they're not taking insurance. Is that correct or not?
This is such a loaded so we had a huge internal debate at our firm that actually got like hostile almost, where we were literally arguing, like attorneys were like, no, it does apply. No, it doesn't apply. So like we've learned now that HIPAA, and I have to be careful. I'm glad that no one make a meme or anything from this. HIPAA, I don't think I'm that popular, but HIPAA does not directly apply if you're not taking insurance, like you said. So if you're certainly not taking Medicaid, if there's no like wellness component that you take, Blue Cross or something, then it doesn't directly apply. We still speak a lot about HIPAA because people just get it. But really, the idea is like there's probably in almost every state, if not every state, there's kind of like some state equivalent of HIPAA. And it's all about safeguarding, PHI, protected health information. So safeguarding the patient info. So even if it's not really HIPAA, there's stuff that looks and feels just like HIPAA. So we'll tell folks like, yes, follow HIPAA. And they'll be like, but HIPAA doesn't apply. And I'm like, it may not, but there's something that looks just like it. So like, so it is interesting. Like we had blogs on HIPAA, and then one of my attorneys was like, you're wrong. And so we got in this whole thing. And eventually I found out they were actually right because of the piece. We went down a major rabbit hole, but we landed on still follow it because it's best practice.
Yeah. I got to, I stepped in it with, our CFO, and she was like, no, it's gotta be. It's like, wow, this is it's a very energy charged topic there. I never knew a HIPAA was so passionate.
Yeah.
But well, I'm glad you cleared that up. So basically you don't have to be HIPAA compliant, but be HIPAA compliant because there's something very closely related to it that you need to follow.
Yeah. And almost again, probably every state has something, because the idea is protecting the patient info. And you're still a clinical provider, like you will absolutely have exposure if that gets out or whatever. So I always tell act as if HIPAA is a thing.
Yeah. What does this entail? So for example, let's say my neighbor comes in and buys skincare, and then I'm talking to her husband. I'm like, oh yeah, I saw Maggie in today. She bought some skincare. Like, is that, you're violating the rule?
So products and retail, not so much. Again, best practice, probably don't disclose. Again, the lawyer, right? Don't talk about anything. But probably, best practices is don't disclose. But in reality, it's not really a HIPAA situation if they bought a retail skincare product, a face wash, so you're probably.
Okay, let me ask you this then. What if, so one of the things that I want to implement is, because I want to have better transparency for what's going on during the consult, right? Because it's really hard to coach the practitioners in there, once they get inside the room, because they're telling me a version of events, but I know that that's not actually what happened. It's just how they remember it, which doesn't make them bad. It's just, I want to have the raw data. Sure. So I was like, why don't we start recording all of these consults? I I would assume we'd have to get the patient's permission. Like, hey, I'm going to record this consult just, for your memory. I'll send you the MP3 afterwards because I'm probably going to say some things you might forget, and you can always listen back to it. As long as, like, one, if we didn't get their signature, would we be in violation? And two, if we did get their signature, would we be like safeguarded?
Yeah, so this is this feels like a bar exam question, but I would say you always give me the good ones. When it comes to recording people in general, I mean, it starts to get a little bit outside our scope, but yes, get their agreement, right? And if you're sending it, it's got to be secure. Like, it's got to, make sure people don't just blast it off via, Gmail. And if it's not a secure server, there's that whole consideration. Getting their signature and their agreement, I think, is fine, right? But it's just got to be housed, right, in your EMR, which should be still HIPAA compliant or close to HIPAA compliant. So yeah, I think given the intent, it's obviously like really beneficial for the patient as well. Just make sure you have everything documented. They sign it, they agree to me recording it. I send it to them in this secure, whatever, password protected, all of that stuff, because that, again, God forbid there's like data breaches. That's when people get in some hot water.
Yeah. So, all right. So you have to send it securely, not like a text message from our company iPhone to their Android.
Right. I would try not to do that because
okay.
That gives me a little bit of agita, and so as my Italian in-laws would say. So yeah, I'd be really careful about how it's going to be sent.
All right. So I think we talked some about this, but I want to make sure that we hit it all. Like, what do med spas need to know about consent forms, patient documentation, and keeping records legally airtight? And are there just some common mistakes you see over and over again?
Yeah, I think a lot of spas will just depend on whatever. There's some great EMR, like Boulevard's amazing, Patient Now. There's great services out there, but I would have some attorney, hopefully us, but if not, some firm spot check the consent.
No, only the Marty Law Group.
I mean, I didn't want to say that, but thank you. So spot check that documentation, because people go to add a new service and they chat GPT, I need a consent form for this new hot thing. It kicks out this like real basic document, and they're like, cool, I'm good to go. So I think, again, all documentation, have the patient sign it, scan it into the EMR if it's not actually like a service that the EMR has in there. But just making sure like the document is robust and talks about the contraindications and all the things, right, that you just want to make sure you're protected. So I would have all that housed. Like, I always tell people, like, you can't, like, more documentation is better than less. Again, we would have the dental board show up, and thank God the doctor's signature was there, and he checked the chart. And because if it wasn't, like, we were like, what's the fine? It's going to be steep. Wow. So I make sure that's all really clear.
Yeah. Okay. And I would say Chat GPT, especially in this day and age, is probably where most people are getting into trouble. I heard it was a few months ago. It's out having drinks with a friend, and the attorney showed up. The party ended, of course. But we started talking about, like, he was reading about how an attorney got disbarred because this attorney was using ChatGPT to cite case law rather than doing the research, didn't fact check ChatGPT, and ChatGPT was just making up like case law or like citing things that just didn't exist. And if you're a med spa owner and you do use ChatGPT, I mean, I've caught ChatGPT making mistakes because I'm like, wait, that's not what you said before. And it's like, oh, good catch. Yeah. And then it course corrects. And the other thing is, like, if you tell it, like, create me an airtight legal document about patient documentation or consent forms, it'll create it. And then you're like, make it even more airtight. It'll redo it all and then, like, make it even more airtight. And if you ask it, like, in perpetuity, it'll continue to adjust it. It'll never say, like, it's good enough, it's airtight, So that alone will tell you that there's gaps there, and you need to have a professional like Justin and his team, like, look over it.
Yeah, I mean, AI, like, we know that, right? It's the future. It's the here now. I mean, AI and legal is this huge thing, as you just said. We are constantly seeing how can we be more efficient at running our business with AI. But
Yeah.
I tell you, the attorney's like, you look something up, cool, that's your starting point. Obviously, you got to go deep into the regulations and all that. And we find it all the time. Like, it's cited one thing from the wrong state, and so we have to kind of backtrack. And it's really interesting to watch it evolve. But yeah, please just don't ChatGPT your document and run off of it.
Yeah, because the goal is for AI right now. I mean, as it continues to evolve, it'll get more robust. The goal is to get you 80% of the way there.
That's right.
So that it saves the majority of your time.
That's right.
And then from there, you're like putting your expertise and your special sauce on it. Okay, two bonus questions real quick. One, if owners are thinking about selling in 3 to 5 years from now, their med spa or just bringing on partners, et cetera, what can they do now to make their practice more buyer friendly from a legal standpoint?
Yeah, I love this question. We do a lot of M&A, obviously, in our firm, and it's just wild how much like private equity and groups have found aesthetics. And we started in dental and we did vet and optometry and other verticals. I get a call every week now from some PE group that's like, hey, we did this. We see you're in Medspas, tell us about it. And it's just wild. So
Wow.
starting to, I always tell folks, start with the end in mind, right? And start thinking long-term. A lot of these groups, and this isn't really hitting on your question from a legal standpoint, but just a lot of these groups are going to want sellers to sign on for like a 3 to 5 year employment agreement, more often like 5 years at least. So people, don't wait till you're like, I'm burnt out, I'm leaving, I'm done, because that's probably not going to get you top dollar. And we're not brokers, but we do enough of these deals that we see like these themes. From a legal standpoint, everything we've talked about, I think making sure those systems and processes are in place and well documented, they will definitely fetch people more when it comes to sell, because a buyer might still look at you if you're super non-compliant, but they already know, man, I'm gonna have to pay my legal department all sorts of, sums of money to get this practice to where it should be with the proper oversight and documentation. So that's going to hit your bottom line. So I think kind of going through all the things we talked about, making sure employees are classified right, looking at your documentation as a whole, making sure the good faith exams are done. If all those systems are pretty tight, the buyer is definitely more likely to say, okay, you know what, Roddy Medspas is pretty easy, it's turnkey, it's ready to go. And we want to offer whatever top dollar for it.
Yeah, I'm going to forego the last question because I think we've covered it in a few other spots. But one of the things that I will say, and I do really recommend that you work with Justin and his team, that they're thorough, they're really communicative, and they're just nice, But like if you're just starting off like in your med spa, then that would be the ideal. And I know you're thinking about getting patients to the door and all that, but it is good to have some more of a foundation. And I know you can reach out to Justin and say like, all right, what bare bones do I need to like start today? And like, here's my budget. Like, and then what do I need that can be pushed down the road a little bit? And I think the fear of the cost sometimes holds people back from having that initial conversation. So I would give that advice because that's something I wish we would have done initially. Thankfully, like nothing happened, but it could have. Secondly, if you've been doing this for a while and you've never had a legal checkup, like go to like Justin and his team and just say, hey, here's our employee handbooks. And I mean, I think that there is a small cost for you to go through it, but like at least you just know where your exposure is. And then he can say, all right, this, and he's done this with Renata and I, so I know. He's like, all right, this like red flag, you got to fix that. These are like yellow, we can put these off to like a later date, but like absolutely do this. And it's really like more affordable than what you think. But then it gives you that peace of mind that if somebody comes and they try to sue or trademark infringement or like, I mean, I know you all don't do trademarks, but anything like that at least you have the peace of mind that like somebody has looked over this, it's fine. Because like if the patient's already had the occlusion, right, or something's already happened there, then it's too late at that point. right? To kind of go retroactive. But
Right.
anything you would add to that?
I think I mean, you hit on the head. We do what we call compliance assessments, and it's really for any, someone at any stage in the life cycle of practice ownership, right? Even if they're kind of winding down in some instances, like people that, can you look at my stuff and make sure, because there is so much increased scrutiny with the private equity, all the money coming in. There's also a lot of eyes on the industry. And you mentioned before, right? We've got people who were injecting Botox at home with no license. We've got, terrible things that have happened. Unfortunately, there's the HIV breakouts in New Mexico at one point. Like, there's just so much stuff that there's a lot of eyes. So I think, again, wearing my, attorney hat is constantly like, let's take a step back, and 100% we want to run a successful business and be aggressive with our goals and push the limits. But like, this is still medical, healthcare, and that's really where the compliance piece is so important. So we started doing these compliance assessments to make sure, like, we take a look. Like I said, send us everything, or like you said, send us your employment handbook. People are embarrassed, right, to be like, I actually don't have employment agreements. We're like, that's fine. Like, we're glad we know. I mean, it's not fine, but like, let's address it.
Very easy to review, right?
Right.
Okay, cool.
I'm like, nothing. Okay, well, so okay, that's going to save you money, I think, or maybe not. But let's take a look at it and identify possible exposure, and then get it straightened out.
Yeah, and we also below this video, I'll link to Justin's compliant quiz that he put together for this, and you can take it, and it spits out like if you're compliant or not based on some questions, which I found really helpful. So no judgment if you fail.
That's right. That's right. That's what it's there for.
Yeah, Justin, thank you so much for your time today and all the advice. Appreciate it.
Thanks, Steven. Thanks for having me.